Good morning, this is your Kelso Report for Monday, February 27th. I'm your host, Clark Kelso. Today we've got quite a few Court of Appeal decisions, California Court of Appeal, involving criminal sentencing and procedure, criminal law, civil rights, attorney's fees, land use regulation, consumer protection, and criminal sentencing. We begin with a case involving criminal sentencing. Trying to perform appropriate calculations of pre-sentence custody credits can pose real problems when the credits stem from multiple charges. How do you allocate the credits among the charges? In People v. Kunoff, the 2nd District gave us a clear rule for at least one of the many variants on the problem. The court decided that under Penal Code Section 2900.5, when concurrent sentences are imposed at the same time for unrelated crimes, the defendant is entitled to pre-sentence custody credits on each sentence, provided he is not also in post-sentence custody for another crime. It's a narrow holding, to be sure, but any clarity in the area of allocating pre-sentence credits is a good thing. Next, in the area of criminal procedure. According to People v. Wheeler, if a trial court concludes that one party has impermissibly exercised peremptory challenges on the basis of group bias, the court must dismiss the jurors thus far selected and quash any remaining veneer, unless the party who made the Wheeler challenge consents to retaining the veneer. Well, in People v. Mata, the defense had challenged one of the prosecutor's peremptory challenges, and the court granted the defense counsel's Wheeler motion. But instead of dismissing the veneer and subsequent peremptories that were challenged and rejected, the judge reseated the jurors instead of dismissing them. The 2nd District held this was error and reversed the defendant's conviction for possession of cocaine base and 2 misdemeanor counts of resisting an officer. When you grant that Wheeler motion, the veneer is supposed to go away. Next, in a civil rights case, under the Tom Bain Civil Rights Act, which provides in Section 52.1 of the Civil Code, for an action against any person who interferes by, quote, threats, intimidation, or coercion, close quote, with the exercise or enjoyment of rights secured by the Constitution or laws of the state. In Shoyoy v. County of Los Angeles, the plaintiff had been detained in jail for 16 extra days as a result of a clerical error. He sued both for false imprisonment and the violation of Section 52.1. The 2nd District held that there were no facts in the record to establish the necessary threats, intimidation, or coercion, and that damages and attorney's fees could therefore not be awarded under the Tom Bain Civil Rights Act. The court affirmed the damages for false imprisonment. Of course, that doesn't give you the award of attorney's fees. And speaking of attorney's fees, in Lin v. Jang, the 2nd District affirmed the Superior Court's order that the plaintiffs in a partition action were not prevailing parties and therefore were not entitled to attorney's fees. The plaintiffs claimed they held an 85% undivided interest in certain property. Well, the trial court ultimately disagreed and held that the plaintiffs were trustees holding the property for themselves and a number of other surviving siblings, all of whom held the property as tenants in common. The plaintiffs rather remarkably claimed that they were entitled to attorney's fees because their costs were incurred for the common benefit of the parties, since the ultimate judgment resulted in ownership interests for each of the siblings. But the courts disagreed, since the plaintiffs sought an 85% undivided interest in the property and lost. The plaintiff's position did not prevail. Section 874.040 of the Code of Civil Procedure authorizes a court in a partition action to apportion the costs either in proportion to the interests or in such other fashion as may be equitable. The appellate court held the Superior Court did not abuse its discretion in denying fees to the greedy plaintiffs. My word, not theirs. Next criminal law case. The defendant was stopped while transporting 1 pound of marijuana from one medical marijuana establishment to another. Although he explained to the officers that he managed medical marijuana dispensaries and had a valid doctor's note for his possession, he was arrested, charged, and convicted of illegally transporting marijuana. The Second District reversed, holding that the Medical Marijuana Program Act, and in particular Health and Safety Code Section 11362.775, provided a defense to qualified patients who associate in order collectively or cooperatively to cultivate marijuana for medical purposes. In applying the defense, the court rejected the Attorney General's argument that it applied only to those cooperatives involving some united action or participation among all members. Well, the statute simply isn't written as narrowly as was argued by the Attorney General. Next, we have a case, well, that was that one. Next, we have a case involving land use regulation. Decisions by a municipality to grant or deny a variance to zoning restrictions are subject to a 90-day limitations period under Government Code Section 65009. A variance had been granted in this case to permit a homeowner to build a pool and spa within a setback bordering the petitioner's property. The petitioners did not file within that period, and the Superior Court dismissed their claims as untimely. The Third District affirmed. Petitioners argued that they had made a timely request for the record, and that Section 1094.6 of the Code of Civil Procedure provides an extension of the limitations period for 30 days following delivery of the record. The Third District disagreed, concluding that Section 65009 was a more specific limitation statute than the general provisions in 1094.6, which dealt only generally with administrative mandamus, and therefore the more specific statute applied. We go back to criminal law here next. The burglarized residence in People v. Tuggle, which was a model home in a development, was cleaned before it opened in 2006, and thereafter was cleaned on a monthly basis until April 2008. After the burglary in November of 2008, the defendant's fingerprints were found on a vase that was on the ground next to a fireplace. When the defendant was arrested in February of 2009, he admitted that he had not been in any of model homes in the development in the previous 2 years. The defendant contended that the presence of his fingerprint on a movable object in the burglarized residence was insufficient to support his conviction, absent of showing the fingerprint could not have been placed on the object at some earlier time. But, given the evidence of the cleaning and the defendant's statement that he had not been in any model home in over 2 years, the Second District concluded the evidence was sufficient to support a conviction. Another criminal law case, this one involving 3 strikes. The Supreme Court of California, as you all know, held in People v. Romero that trial courts have discretion to strike 1 or more 3 strikes findings. In People v. Smith, the Second District vacated the defendant's 150-year to life sentence after being convicted of custodial possession of a weapon, 2 counts of resisting an executive officer, and 3 counts of battery by gassing, crimes committed in the county jail. The Second District directed the trial court on remand to reconsider exercising its discretion under Romero and to consider certain other ways in which it could exercise its discretion to impose something less than the sentence the trial court itself knew was excessive. Now a consumer protection case. California's anti-spam law can be found at Section 17529 of the Business and Professions Code. The law makes it unlawful to send commercial email advertisements with falsified, misrepresented, or forged header information. The purpose of falsifying header information in an email is to get around anti-spam filters. A recipient of unsolicited email ads may bring an action under the law to recover actual damages, if any, or liquidated damages of $1,000 per email, plus attorney fees and costs. The email sent by the defendant had falsified information misidentifying the source of the email as mostly non-existent companies or false senders. The company argued that federal anti-spam law preempted California statute. But the appellate court held that a savings clause in the federal law for state statutes regulating falsity or deception was broad enough to save California's law, and the appellate court therefore affirmed judgment against the corporation. But the appellate court did reverse the trial court's imposition of personal liability on the CEO, because the evidence showed he did not personally authorize, endorse, or ratify the improper email advertising scheme. And that's it for today's Kelso Report. Have a great day in the law.